Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to part 2 of the closing arguments on YNW Melly. So, before we get to that, the defense, when you close, we do a closing argument, it is where the rubber meets the road. And it's your last opportunity to speak to the jury. So hopefully you did your job well, and hopefully they're listening to you. But before we get to this is brought to you by ContractsCounsel.com. They're a partner of eSign, so we're still with eSign, but this is Contracts Counsel. And this is a call to action kind of thing we're doing with them because they've got a lot of clients, but they don't have enough lawyers. So if you're a lawyer and you are looking to make a little extra money from home, writing contracts for certain clients, it's a great way for you to sign up and make some dough and help some people that need some help. So go to ContractsCounsel.com. You can work from the comfort of your own home. What the hell? What's better than that? And here's the thing. You can do it at your leisure. You don't have to have a set schedule. And they've got so much work, you can work as much or as little as you want. So go to ContractsCounsel.com. A very effective way for you to work from home and make some dough and help some people too. So let's get into this. We're doing the defense closing. Now, this is part 2 of the YNW Melly. I love doing a closing argument, especially if I've got some facts on my side. And I really like these lawyers. Let's see how they do.
I trust you had a nice lunch. This is the defense counsel's opportunity to address you.
So they're coming in right after lunch. Guess what happens after lunch, after you just got done eating a sandwich? I've had that happen before. And then you pound on the table, and you wake them up a little bit.
Please give Mr. Adamstein seat and attention that you previously displayed to Ms. Bradley. Counsel, if you're ready, you may proceed.
Is he a principal or a shooter? That's what the state addressed you folks just a few moments ago before you went to lunch. And the reason they said that is because they don't even know. Otherwise, they would select either him being a principal or the one who caused the death of Williams and Thomas. It's that simple. Where is the fire?
So you're not going to have a PowerPoint, I don't think, from this guy. Is old school. He's got no hair. He's been around a while. And he's going to give you a fire and brimstone speech.
Was a message. They say it refers to guns. That's their interpretation.
See, they get right into this. The first thing that I do is I educate the jury on what the law is in terms of burden of proof, presumption of innocence, and beyond a reasonable doubt. One of the things I always say in every case is that the evidence should be viewed through the prism of the presumption of innocence. You should look for doubt. Doubt is healthy. Doubt is what you need to find, and there's doubt all over this case. And when you do that, at least in it's a stylistic thing, but when you do that at the beginning of the closing argument, then everything that you say is viewed through that lens, or at least you try to get the jury to see it through that lens. And then you wrap it up saying, this is what we showed you, and you do that same prism analogy. That's what I do. It's just not everybody does it the same, and you can't copy somebody else's style. You got to have your own.
My interpretation, based upon the evidence, is where's the weed, the marijuana? That's the problem here, folks. They're interpreting it as opposed to calling these various people to tell you what they mean. They mentioned Frederick Gibbons, Frito Bang, Mariah Hamilton, Peasy, Patrick DeLoach, Dontavius Withers.
Objection, Your Honor, Halliburton.
They opened the door.
Stay.
We don't have a burden. As the court told you in jury selection, the burden of proof is on the state.
So there you go, burden of proof. The burden of proof is on whoever brings the case. So if I sue you because you ran me over, well, I got to prove my damages. I got to prove the case. The state is charging this case. The state has the burden. The defense has no burden.
And the court told you during jury selection that this is a first-degree murder case, wherein the penalties are either life without the possibility of parole or death. You folks are going to determine this young man's fate. And they come in here and give you alternatives. They come in here and give you their interpretation.
Now, I'm not sure what the rule in Florida is, but generally, a jury is not supposed to consider the outcome or the consequences of a guilty verdict. And so it must be permissible because she didn't object.
When we don't have to do a darn thing. And that principle was so important that His Honor read you that instruction at the beginning when you were going through the process. That he just read it to you before the state got up and gave their opening closing statement.
See the way he's talking? It's like more conversant. And he's like more relating to the jury, and he's got an outrage, and you should be outraged because you should feel the same way I do about this case. And what is the state trying to do to you as the jury? That's an effective way to argue this case.
I told you that this young man has pled not guilty. That means you have to presume him innocent.
What do we say? Burden of proof? Now presumption of innocence. Soon we're going to hear reasonable doubt.
That means that that presumption stays with him until and if the state of Florida can prove their case beyond and to the exclusion of every reasonable doubt. The judge goes on to tell you, and it's in your packet of jury instructions, that the defendant, Jaylap, Melly, is not required to present any evidence or prove anything.
So, in other words, we only presented one witness, and you can't hold that against us if we only presented one witness.
So it's nice that they're interpreting these things, but the bottom line is they don't even know. Because they've given you just two alternatives. Either he's the shooter or the principal. Make up your mind. Tell these folks what it is. Now, how do you go about doing this? Well, the judge gave you an instruction on that. You're to look at the evidence that's been presented to you. Remembering, we don't have to do a thing. All we have to do is show up and behave. Now,
show up and behave. Well, if all you did was showed up and didn't say anything, you would be sued for malpractice.
I don't know if I behaved totally correct during the course of this trial.
I don't know if here's the thing. That's one of the things I say. I said it in my last trial. I said, look, I have my way of doing things, and sometimes I get a little animated, sometimes I get bombastic. And if I have done anything throughout this trial to offend you or that you thought was improper, hold it against me. Don't hold it against my client.
So, on behalf of us, let me apologize if I have or we have offended anyone.
I do the same thing.
And I would ask you, I would plead with you, if I or any of the other individuals have done anything to irritate you, don't take it out on this young man. Still hold the burden of proof to this table. Now, why do they have the burden of proof? Because they are the state. They are the government. As we learned in this case, They have the police department of Miramar. They have the Broward Sheriff's Office. They have the DNA labs. They have experts, the FBI. They have everything at their disposal. And that's why our system of justice is different than anyone else in the world. We recognized a long time ago that when the government accuses somebody of a crime, they have the money, the resources, and the person power.
And accusing somebody of a crime and jailing them is a very serious thing. Depriving you of your liberty is just an absolute, it's the utmost taking that the government can do. And if the government is able to do that without having to prove their case, well, then they can just lock up anybody for anything. And we've saw, over 200 years ago, 250 years ago, that isn't the way we want to do business.
To attempt to prove to you all that a person has committed a crime beyond and to the exclusion of every reasonable doubt. Now, how do you go about doing it? And before I get
So he's got a folksy way about him, that seems relatable.
into that, first of all, let me also thank you, because we have interrupted your lives for it seems like months. And we have put a horrible burden on your personal lives, your family life, and what have you. And all of us applaud and thank you for your service. You folks have gone way beyond the call of duty. And I think.
And then they get sequestered after this. And getting sequestered is probably the right thing to do in this case, but I've always been opposed to it because you're treating a jury like they can't do their job without, locking them up, basically.
I want you to pay particular attention to Dr. McDougall and Dr. Saunders. Because those two doctors, one being the chief medical examiner of Broward County, the other one, an associate medical examiner, I think now employed in West Palm Beach, say to you that the first shot to Williams and Thomas were fatal, deadly. Why is that important? Because according to Sergeant Williams, Thomas's injury to his hand came first. It was a defensive wound. We know that couldn't happen based upon the medical testimony. So you either have to disregard the medical examiner and accept what Williams' testimony is, or I suggest, now that you have four experts, contradicting Williams' testimony, and that is Bello, Special Agent, FBI Agent Collins, and two medical examiners, conflict with Williams' testimony, that you should take Williams' testimony and ignore it, toss it out.
There's a doctrine called falso nulo, falso omnibus, meaning if you're lying about one thing, you're lying about everything. And so if you're lying about one thing, you can completely disregard all the testimony. That's what he's talking about there.
You can't have it both ways. It just doesn't work. And then we get to really their star witness, two star witnesses. Sergeant Williams, and I think I've talked a bit about him. And I think the most amazing part of his testimony is that he does not get involved in this case until 3 years after the incident. Again, at the request of the state. Again, because they realize they have problems. And I applaud them to recognize they have problems. And miraculously, as I told you earlier, even though the Jeep was searched for hours and hours, processed for hours and hours, he finds additional evidence.
That is curiouser and curiouser, don't you think? Because all of a sudden, 3 years later, you find a key piece of evidence, or you figure out where the hole is in your case, and all of a sudden it just magically appears. That's a little suspect.
2 projectiles that everyone else missed, and a blood stain that is.
How the fuck do you miss those bullets? I mean, if Williams finds bullets in there 3 years later, that just doesn't. That is a little suspect. Any double homicide is a big deal. Any double homicide. But this one was a high profile, probably the highest profile case ever to come out of Fort Lauderdale. And for them to miss the 2 bullets, you know, I had a case where I was trying to prove that the state planted some evidence on my client. Murder happens. He gets picked up the next morning. They VCAT, the violent crimes arrest team, go and get him, and he's coming out of a gas station. They search him, put him in the back of the squad, handcuff him, put him there, bring him over to the homicide unit. They search him again, bring him into the homicide unit. Then they bring him over to the jail where they search him again. Oh, now they magically find bullets in his pocket. So I had the jury coming along with me, or so I thought. And then all of a sudden I get these, and then they ask him. They go back to the jail and ask him about the bullets in the pocket. He says, "I didn't know anything about that." Well, he didn't stay off the phone, and he's talking to his cousin. And he says, "Of course I knew the bullets were there. I was just being a smartass." So anything I was trying to do up until that point got jammed up my ass. So when you accuse the government of planting evidence, which is what he's doing here, you better be sure that the jury is going to come along with you on that. Because if you think you're full of shit on that, you're sunk.
And that when he did his analysis, 2 important things occurred. He didn't go in there blindly to do any analysis. He told you that the prosecutors in this case told them that the defendant in this case was this young man. And we need you to do a trajectory analysis to put him on the scene. Now, I suggest to you could have a Jolly Green Giant and a midget. And if you give them the dimensions, the height and his arm length, with this mathematical formula, you could say the Jolly Green Giant or the midget was a shooter in this case. They would either be closer to the car or further from the car.
One of the things about experts is they're allowed to opine. In other words, give their opinion as to what happened. And, or not the ultimate issue of fact, but they're, with their opinion about what the evidence is and what the evidence means. And that's what he's talking about. He's saying, look, you could have a Jolly Green Giant or a midget, and they would force fit their conclusions to meet that person.
Depending upon their size. If you want to do an analysis, if you want to do an investigation, if you want to figure out who the shooter is, why do you point to this kid and tell him, this is what we want? Why do you do that? This is...
So just a stylistic thing, in federal court, you cannot parade up in front of up and down in front of the jury. You have to have a hand on the podium at all times.
The great investigation? This is what they want you to do in order to render a verdict that could take him...
Your suggestion.
There's a properly signed.
Over, proceed.
And
She just objected as something was improper. I couldn't quite hear what she was saying. But I hate it when they object during my closing. I mean, he didn't. I don't think they objected really during their closing, but it happens, and it upsets your rhythm a little bit. But
Tell him that he's going to live life in the state penitentiary without parole or be on death row. This is the investigation they want you to rely upon and say it's proof beyond and to the exclusion of every reasonable doubt? I guess so, according to them. And they call Danny Benitez. Who the heck is he? He was on the stand for all of about 2 minutes. Danny Benitez gave Detective Moretti the surveillance tape from the Montessori school. You watched it. It showed, I suggest, nothing probative to implicate this young man in it. But we learned, not from him, but from Moretti, that he doesn't go to the drugstore on Miramar Parkway to check their surveillance tape. He doesn't go to Applebee's to check their surveillance tape. He doesn't go to Polo Tropical or the gas station or the bank on Miramar Parkway to check their surveillance tapes. When the car's on 184th Avenue, he doesn't go to the fire station to check their tapes, surveillance tapes. Doesn't go back to the two elementary schools, Sunset Lakes and West Broward Elementary, to check their surveillance tape because he knows it all. He knows it. How do you know it if you don't check?
that is, a lot of times cops will, they know what's going on. They know that, this person is guilty. Well, they think they know. And then they selectively do their investigation. And so that's one of the things that when you cross-examine a cop, well, you didn't do this, you didn't do this, you didn't do this, you didn't do this. And the more you try to show that it's an incomplete investigation, which leads to reasonable doubt.
How do you know something unless you investigate? We don't have to do a thing, folks. We don't have to do anything except show up. And begrudgingly, we did. Where the Montessori school was, on Pines, there was a tractor supply company. And another school. Why don't you get that? And come in here and say, you know what, folks? We checked all of this. Instead, what they do is take a helicopter ride 4 or 5 years later. And we have to sit here and watch as they fly the route. And we have to watch how they drive the route. Not checking what the traffic conditions were that day, back 4 or 5 years ago.
Well, it was 4 in the morning in the middle of fucking nowhere, so it's probably, this is, you can go down a rabbit hole, and if they're not with you, and I suspect they're not with him on this issue.
Not checking what the weather was.
And here's the thing, all this business about, begrudgingly, we didn't do this, we didn't do that. We don't have to do anything. Not so much so in this kind of case, where you have a he said, she said type of case. The jury wants to hear from you. They want to see you produce something, even though it's not your burden to. And you really got to hammer that home. But they did put on a witness.
5 years ago, in October 26th, what's the purpose of that? Just to add more of what I suggest is a smokescreen. You look at all this and say, heck, man, 100 exhibits.
Yeah, and 2 of them are dead bodies. He's not really talking about the dead bodies at all and the deaths of these 2 young men. That's proven. Just a matter of who did it and how is an issue.
500 photographs out of a cell phone. All these text messages. What does it mean? Hopefully, for the state, you'll say, hey, where there's smoke, there must be fire. And say, hey, too bad, young man, too bad.
Let's just talk about smoke and fire as an analogy. So, you got, if you have a little smoke, in terms of proof, that would be some proof. If you have a little smoke and a little fire, that might be, preponderance of the evidence, just slightly more true than not. If you have a conflagration where it is just a raging fire, that's probably proof beyond a reasonable doubt.
Fall into that trap. And then we get to the lead detective. Well, before we get to the lead detective, I think I missed someone. Trevion Glass, the individual who got into the red Mitsubishi. The man who is convicted of 2 felonies. Now, why is that important? Because the judge read you an instruction on some of the factors to look at.
So, when you have a witness that has a felony in his record, I don't think that that's all that powerful of a tool for impeachment. Just because they have a felony, that means they're a liar? Generally not. However, if they're in custody and they're trying to get out and be free because they've got pending charges, now they're cooperating, that's a motive to lie.
In determining whether or not to believe a witness or not. And he told you that one of the factors to look at is whether or not the witness has been convicted of a crime. Trevion Glass, the state calls, as their star witness, basically, to say Melly never got into that red Mitsubishi. And he told you one interesting thing. He said he's got a case pending right now, and he doesn't want to go back to jail. Now, who has the authority to put him in jail? We don't. There's only one person who can put him back in jail. And that's the state of Florida, whether it be through the state attorney's office or the police department. I shouldn't say that. This man, young adult, is a professional. They say because you didn't show up at 1 or 2 jobs, that what the heck? They have no idea what the contract was. They have no idea how much money was involved. They have absolutely no idea. Why? Because there was no investigation. Play this. And they want you to believe that he's a cold-hearted murderer. When quite to the contrary. You saw the tapes. You saw that he's a nice young man.
Now remember our very first video. You guys should go back and watch our very first video. First of all, I look like a moron. It's kind of funny when you think about it. But our very first video reaction we did was Murder on My Mind and Melly. It's really interesting. Keep in mind they never used any of that in this case.
Folks, the worst thing any lawyer can do is sit and see a misjustice, no matter what side of the fence you're on.
The worst thing a lawyer can do is see a misjustice, no matter what side of the fence you're on.
Especially when you're talking about a 23, 24-year-old kid. Man, young adult. To me, he's a kid. because I have children older than him.
Objection, Your Honor. Sympathy.
You can't personalize it.
Sustained.
The worst thing you can do is sit and see a misjustice. And we have sat here for months, starting in April, waiting to see the evidence. And I suggest to you right now, you should have more questions than when you were selected as jurors as to what really happened. And there was a gentleman who recently said,
Let's just talk about this for a second. You got Melly in the back of that car. You just do. And you've got the trajectory. I think that evidence was pretty powerful. You don't have a murder weapon. And you've got Portland lying about what happened. But you got Melly's phone in that area and putting on steps. In other words, he gets out and he walks away. Powerful stuff.
that our system of justice is broken. I don't believe that. But it got on TV and it was all over national news saying, I think our system of justice is broken. If you want to do justice in this case, and you want to follow His Honor's instructions of proving, making the state prove their case beyond and to the exclusion of every reasonable doubt, you will go to the verdict form and check off count one. We, the jury, find as follows to the defendant: not guilty. We, the jury, on count two, find the defendant not guilty. You may think he might be involved. That's not enough. If you waver and vacillate, that's what reasonable doubt is all about.
If you waver and vacillate, one of the instructions that's very commonly given is that reasonable doubt is the amount of doubt you use in the most personal and important affairs. Okay? And then, but there's really no mathematical formula. There's no other definition. So reasonable doubt is whatever they think it means. And there's no way to really challenge that. So I always say, for example, if you're buying a house, if you're having a serious surgery for a child, would you get a second opinion? And if you're, if you think about you'd like some more information, that's reasonable doubt. So it's really important to hammer that home, and because we have three different types of proof in our systems of justice: preponderance of the evidence, slightly more true than not; clear and convincing evidence, kind of somewhere in between reasonable doubt and preponderance of the evidence, so it's probably 75%, and anything over and above that, like maybe 95% is at least is proof beyond a reasonable doubt. And here's the thing: it's not just proof up to a reasonable doubt; it's beyond a reasonable doubt, and how far beyond that is up to the jury.
You want to make sure the justice system stays intact. There is only one just verdict based upon the evidence they present. And that is, state, we just can't rely upon this beyond and to the exclusion of every reasonable doubt, because there is a lack of evidence, there is a conflict in the evidence, and the evidence itself and the investigation itself stinks. I'd use another word, but I would probably get held in contempt. But I think you know what it is.
Or it sucks.
So say we all.
you get to the end of a big case like this. I mean, it's a big case. So now the closing arguments are in, and so what the judge does, and we're not going to react to that because it's really boring, the judge will read the instructions to them. And then they swear in the deputies, and then they bring them into the deliberation room. First thing they do is they select a foreperson, then they sift through the evidence, and sometimes they do a vote right away, but it's all in secret. And if they want to watch anything, they want to watch Borland Henry's statement again, they have to all come back into court, and everybody's got to get assembled, and they watch the whole thing, which I bet they don't do that. I think there's an overwhelming sentiment that Melly is going to go down. Is he? I don't know. The state or the defense really took a gamble with bringing one witness and seeing if they bite on that. One person could bite on it, but they need 12. They need 12 people. So this won't decide whether he gets the death penalty or not. This will decide whether he's guilty or not. And then there's a penalty phase after that if he is found guilty. So this has just been our reaction to this is part 2 of the closing arguments, reacting to the defense's closing argument. Now they're sequestered. And so your guess is as good as mine as how long they're going to take to decide this case. I would bet they come back tomorrow or fairly soon. They've been at this a long time. They're tired. And they're away from their families. They can't call, they can't write, might be able to watch a little TV, I suppose, but I'm not sure what the rule is on that. But they won't get newspapers, they won't get social media, so they're really isolated. It sucks to be a juror, but you know what? It's an important part of our judicial system. And it's a one time where citizens are called into action to participate in government. If I screw up, there's a remedy for that. If the judge screws up, there's a remedy for that. If the prosecutor screws up, there's a remedy for that. If the jury screws up, there's no remedy for that. So, remember, if you're a lawyer, and I know you're out there, go to contractscouncil.com and sign up so you can do a little bit of work from home and writing contracts for those who need it, because they need a lot of lawyers and they're really hurting for lawyers. So we'll see you next time here on Criminal Lawyer Reacts. Make sure you sign up for our Patreon. Make sure you subscribe. Follow us on Instagram. Follow us on Twitter. Get our numbers up. We are so close to 1 million. Michael, our content genius, is depending on you. Criminal Lawyer Reacts. We'll see you next time.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, please, is that my God.